This court will come to session. Let me understand the details. You, the plaintiff, seek first a determination that the contract wherein you agreed to supply milk the defendant's school district at an agreed price be terminated without further liability on the grounds of legal impossibility or impracticality, because of the occurrences of the events not contemplated by the parties, which makes performance impracticable. And second, a determination that the defendant school district has authority to unilaterally relieve the plaintiff of its contracts without violating the New York State Constitution. Is that correct? What can I say except I am legally exempt from this contract? Did I make a year contract to supply the school with milk at 76 cents per half pint? Yes. But that was before the U.S. sold a huge amount of grain to the Russians, as well as all the crop failures. This spiked raw milk prices up 23%. I am going to lose over $7,000. It's impractical for me to fulfill the contract. I am the school district of the city of Elmira. You will honor your contract, you will fill your delivery trucks with milk, and you will restore our schools with cartons of milk. You should have anticipated prices to rise based off of past trends. Well, according to Mineral Parkland Co. versus Howard, I'm in the right. I'll pay you a certain amount of money if you get all the gravel off my land. Sounds good. What? I can't clear this gravel. Half of it's underwater. It will dull my claws. This wasn't part of the deal. It will cost 10 to 12 times as much to shine them up again. I won't do that. And the worker didn't have to. He was relieved of his obligation to clear the gravel underwater. Oh yeah? Well, let me remind you of the transatlantic case. Off I go to deliver this wheat to Iran. Sorry, but the Suez Canal is closed. What? Now I have to travel around Africa to deliver this wheat. Hello, here's your wheat. You will have to pay me extra because the canal was closed and I had to travel around Africa to get here. What? I'm not paying extra. You should have anticipated the closure of the canal when we agreed on the cost. And the court said he didn't have to pay the extra cost because his case, like yours, doesn't fall in the impossibility category. You aren't dealing with death or incapacitation, destruction, or an act of God. You also don't fall under the impracticality category. The duty that you have to perform is not unfeasibly difficult or expensive. Order in the court. The court has a verdict. The court rules in favor of the defendant. Although both cases are commended for your arguments, the court finds the 8.7% above the bid price is not comparable to the 10 to 12 times as expensive to Mineral Park Co. versus Howard case. Also, the price of raw milk was not totally unexpected, and the risk of a substantial or abnormal increase in the price of raw milk can be allocated to the plaintiff. The plaintiff's motion to withdraw the contract is denied. The contract will be honored. We should all learn a lesson from this. In Joshua 12:15 it states, "And if it seem evil unto you to serve the Lord, choose you this day whom ye will serve, whether the gods which your father serves that were on the other side of the flood, or the gods of Amorites, in whose land ye dwell. But as for me and my house, I will serve the Lord. Sometimes we seek to outbid everybody at any cost without paying attention to the consequences. Ezra Taft Benson states, "You are free to choose, but you are not free to alter the consequences of your decisions."